Everyone, I am S. Prakash, Assistant Professor, Department of Commerce, Dr. SNS Rajalakshmi College of Arts and Science. My topic is Industrial Law, Unit 5. The topic name is Employee State Insurance Act 1948. This act may be called the Employee State Insurance Act 1948. It extends to the whole of India. It shall comes into force on such date or dates as the central government may, by notification in official gazette, appoint, and different dates may be appointed for different provisions of the act. For different states, for different parts thereof, it shall apply in the first instance to all factories, including factories belonging to the government other than seasonal factories. The provided that nothing contained in this subsection shall apply to factory or establishment belonging to or under the control the government of whose employees are otherwise in the receipt of benefits substantially similar or superior of the benefits provided under the act. The Employee State Insurance Act 1948, it is a ESI, the significant piece of social welfare legislation in India aimed at providing certain benefits to the employees in case of sickness. So, the appropriate government may, in consultation with the corporations, and appropriate government is a state government with the approval of the central government, after giving 6 months notice of its mention of so doing by notification in the official gazette, extend the provisions of the act if any them in any other themes. So, duly appointed means appointed in the accordance with the provisions of the act or with the rules, regulations made thereunder. The next is the key features of the definitions. What is the key features of definition means? The welfare legislation for organization sector workers establishes a self-financing health insurance scheme managed by the Employee State Insurance Corporation and autonomous body under the Ministry of the Labor Employment. The legal definition is the provided for certain benefits to employees in the case sickness and maternities and injury and make provisions of related the matters like medical care and the dependents. So, who is directly employed by the principal employer and any works of the initial and preliminary to are connected with the work of the factory or establishment, whether such as is worked done by the employees in the factory of establishment or elsewhere. So, who is employed by or through and imitate the employer on the premises of the factory establishment under the supervision of the principal employer or his agent on work which is ordinarily and part of works the factory of establishment. So the establishment is connect to the another's, it is a whether to the preliminary of actions. So the preliminary actions is very clarity and development in these sectors. The next is the scope and applicability of the USA. It applies to non-seasonal factories and establishments like shops, hotels, educational institutions where 10 or more persons are employed. Wages sailing, the applicable to employees earning up to 21 per month, 25,000 for persons with the establities. The covers all states and union territories of the where item impacted. So, the provided that an employee who is have wages including remuneration for overtime work exit such wages as may be prescribed by the central government at any time after and not before the beginning of the contribution period shall continue to be an employee until the end of that period. The exempted employees means an employee who is not liable under this act to pay the employee's contribution. The family means all or any of the following relatives of insured person, namely a spouse and a minor legitimate and adopted child dependents upon the insured person, a child who is wholly dependent on the earnings of the insured person and who is receiving education till he or she attained the age of 21 years, and unmarried doctors. Types of disputes that may be referred. The type of disputes is a discharge, dismissal, workman, wages, hours, work, leave, bonuses, and etc. And continuation services of employment. Once reference is made, the tribunal court must resolve the prescribed time. Thank you.